the appeal is filed, no construction or alteration may commence until all administrative proceedings are terminated. I would like to take this opportunity to introduce Philip McCorkle, who will be presenting the project for Mr. and Mr. Nicole this morning.
Good morning. My name is Philip McCorkle, and I am completely unprepared to speak this morning. We have a consultant that was to make the presentation. I was going to observe, but she's not here, so I'll do the best I can. If you'll we'll go through the slides. This is the location of the project. I am at least familiar with it. So it's 20 Taylor Street at Tybee Island. It's one of the batteries from Fort Scriven. And there has been a house on this site for quite some time. It's now been demolished, and my client would like to build another house on the same battery. We'll just go through the slides. That's just a plat of the property, which doesn't add a lot to the discussion. Please go on to the next one. That is the view of the battery from, I believe, the west. On the other side of the battery is a 6-unit townhouse development, which is the closest really neighbor to the site. This just shows the DNR jurisdiction line, which is, I don't know if you have your own materials in front of you or not, but that line that does like a U about halfway through the site.
We have one person signed up for public comment. I'll call on Chris Sotis. I pronounced that right, I hope, Chris.
You did. Thank you. I believe our concerns have been answered. I'm Chris Sotis. I represent Seascape Condominiums, which is the 6 units next door. I'm one of the owners and the lucky guy to be the association president. And our major concern here again was the utility platform, and Mr. McCorkle did get back to me yesterday afternoon that they have agreed to move the platform to the other side. We were concerned about the proximity, the way these structures sit that would be right in front of us, the noise, etc. And they've agreed to push it over on the other side of the property. So other than that, that was our major concern. As long as this platform is being moved and approved in that fashion, we really don't have any other comments about the structure with the DNR at this time.
Thank you very much. Thank you. Any questions from the committee for staff? Hearing none, Chair will entertain a motion. Chairman, make a motion to approve. We have a motion. We have a second.
Second.
All in favor say aye. Aye. Any opposed? Okey-doke. Thank you very much. Thank you all for coming.
At this time, I'd like to introduce Dan Busey, who will be providing an overview of the project. Dan?
Thank you, Carl. Good morning. I'd like to introduce Patricia Barmeyer of King Spalding is here with us today. Jim Gilbert and Bill Edenfield from the Seattle positions. Any questions I think we need to answer?
Can you talk closer to the microphone?
Yes, sir. The project location is the Beach Club Resort located on Seattle. What we are requesting at this time is placement of seasonal and year-round structures in the shore protection jurisdictional area. As you can see, there's been numerous letters of permission issued over the years for some of the activities. We are, go back one please. We have a very large project area of jurisdiction of 201,787 square feet. We have existing impacts that were previously permitted of 8,664 square feet of hardscape, 2,516 square feet playground area, and 28,000 square feet manicured lawn and landscape area, almost 1,500 square feet. We are proposing at this time requesting authorization for seasonal impacts to include 2,975 square feet for watercraft storage. Where Carl is pointing right there. That's in a bare sand area located between the dunes. 1,376 square feet for a volleyball court. The location that Carl's pointing right adjacent to the sailboat storage area. Again, on a bare sand area between the vegetated dunes. And 170 square feet for a mobile food service unit. The total seasonal impacts would be 4,521 square feet. The permanent or year-round impacts that we're requesting is 119 square foot wooden stage located in the lawn previously permitted area, and 88 square feet for 2 first aid lifeguard stations, which are located in the non-vegetated areas down by the west of the beach. Of course, those are safety first aid lifeguard stations that we need to do year-round. The year-round existing proposed impacts would total 11,387 square feet, which is 4% of the jurisdictional area. Seasonal impacts 2.4% of the jurisdictional area.
Thank you, Carl. Special conditions.
Thank you. Should the committee find the proposed project to be in the public interest, staff recommends the revised standard condition I mentioned earlier and the following special conditions. The permittee is not authorized for motorized vehicle operation within the project area other than along the west sand beach, consistent with current beach driving authorizations and rules governing its issuance. During the period of May 1st, October 31st, all areas must be surveyed daily by a person in possession of the DNR's Seaturtle Cooperative Permit prior to commencement of any seasonal or year-round activities. Number 3, it states that the permittee may be required to provide a post-construction survey.
Thank you, Carl. We have public comment. We have, first up is Mr. James Holland.
Thank you all for being here and allowing me to talk today, because I didn't want to be here to talk today. I think this could have been postponed for a while. And I am now, at this time, I am requesting the hearing to be postponed until this application can be properly noticed and time allowed for the public to make their comments. I hear no motion, so I'll move on. The one thing that I would like to do, I'm going to vary from these comments. These are my official statements, comments that I have given y'all in writing. There wasn't time provided. There wasn't time provided for me to give you these beforehand, so I gave them to you this morning, okay? Now, the one thing that I do want to say is I support the staff's official finding that there'll be no additional driving in this area. And I thank the staff very highly for doing that. They had to be brave. Thank you for that. I want to read one thing to you, and it's 12-5-232, paragraph 8, the dynamic dune field means the dynamic area of beach and sand dunes varying in height and width, the ocean boundary of which extends to the ordinary high water mark, and the landward boundary of which the first occurrence of either of 5 live native trees in the light for me this far, 20 feet in height or greater, or of a structure existing on July 1, 1979. The landward boundary of the dynamic dune field shall be the seawardmost line connecting any such tree or structure as set forth in this part to any other such tree or structure if the distance between the two is a reasonable distance not to exceed 250 feet. The reason I think this is important is because I don't learn a lot from books. I learn a lot from life experiences. But when I can put the life experiences together with what the book says and it makes sense, then I can talk about it. The dynamic dune field is not where the sand shared system ends, it's where it begins. For instance, Anytime the tide brings a log or something in off the ocean, it brings it up on the shore. And then as the tides increase, and it's not too heavy, it will continue the movement of that right on up to the dune line. And while that's occurring over time, what happens? The sand shearing system kicks in. It starts covering this object with sand. That's all right, I'm not going to use it up. I'm just explaining to them what's happening out there in layman's terms, see, where I can understand it and everyone else can understand it. The sand shearing system starts with the ocean, starts with those strong tides bringing the sediments in and moving them forward up to the line of where humans interact with it up in the green lawn area. Now, in this revised plan, they are talking about, they're asking for less. I'm talking about less footage, less square footage. Well, on paper, maybe so, but in real fact, they're asking for the same old, same old. There it is. Look at it. Look in front of the beach club down to where the activities actually end, and you'll see the dynamic dune field and the dunes are intact all the way through. But up there where humans are impacting and them going in and out with vehicles constantly, fragmenting the dunes, and then it's the same thing all the way to the north. The Shore Protection Act says, no, we can't do this. Staff just proved it. Stop this driving. Don't let no driving be out there. All right. When I say they're asking for more of the same, what did I just talk about with the dynamic dune field, where it starts? Look at what's sitting in the high water mark in this photo dated 1/28/15. Beach equipment, okay? Violation of the dynamic dune field. They say, well, all we're asking for is to let us put this stuff back in the dune field where it's always been. We've always put it there for decades and decades, and we've always drove in there for decades. And if this is true, July 1, 1979, they violated the law. Not my fault. Like this one gentleman before me, I don't create the laws. All I ask is that these people enforce them. These laws have not been enforced since 1979. Why? Commissioner, why? You see the impact. It's very visible. Can't hide it. Now, I am personally, as someone that cares, asking that this body deny this permit. And there's the reason why. You don't need it in a book. Thank you.
Thank you, Mr. Holland.
Thank you very much. My name is Alice Keyes, and I'm the Associate Director at an organization called 100 Miles. Our mission is to protect, preserve, and enhance Georgia's 100-mile coast. Thank y'all so much for allowing me the chance to talk to you today. 100 Miles is here today to express not concern for what is in the permit, but what is not in the permit that you're reviewing today. Sea Island is, without doubt, a very important resort and economic engine for the Golden Isles in this area. We are very happy with the work that they are doing to raise awareness about the majesty of the Georgia coast. The naturalists on Sea Island do an incredible job of educating folks about the importance of wildlife, the marshes, the dynamic dune system, and we are very happy that they bring in so many guests during the summer months. It's during the summer months, though, that the beach activity is known to include chairs and structures for chairs to be stored. This is something that was included in the October 2014 permit that you received, permit application that you received, but it is not in this permit that you're reviewing today. The use of the equipment is significant. I've heard between 500 and 1,000 chairs can be stored on the beach in any given day and have often been left overnight. This may not seem like a big deal, but it is a huge deal for the sea turtles that come to those beaches during the same months when those chairs are going to be there. It's documented. There have been some documented cases of sea turtles coming onto Sea Island beaches to nest and experiencing barriers and having to turn back because of those barriers. It's true they can continue to try and find other places to nest, but after so many tries, a sea turtle will do what they call as a false crawl. They will actually drop their eggs without nesting, constituting the loss of about 120 eggs. I think that's the estimate for the number of eggs in one pregnant sea turtle. That could potentially constitute a take under the Endangered Species Act. Should this committee grant the permit with this known activity that will be happening, we're afraid it will set a very dangerous precedent for other beach resorts and communities that are dependent on summer activities. There are some potential solutions to this problem, something that will not deter any of the beachgoers or the nesting sea turtle habitat. And we feel that it is critical that this committee require that the applicant include the beach chairs as well as the recreation equipment and storage of those in the permit application. Should the committee choose not to address it, we fear that we may be violating the federal law that is designed to protect these species and their habitats. Again, there are possible solutions that we can come to that will protect both the integrity of the resort and the beachgoer experience as well as the endangered species. Thank you again for your opportunity to talk to you today.
Thank you, Alice. Mr. David Kyler, and Mr. Kyler, you have been granted 3 additional minutes from Janice Browning, I'm sorry.
I have a very brief statement. Can I donate my time to another speaker?
Yeah.
I'm Dave Kyler with the Center for a Sustainable Coast, and I would just like to reiterate the 2 previous speakers' concerns, especially Jim Collins, that if this indeed does constitute a violation of the Shore Protection Act, which it appears to, that it's long overdue in being corrected. I'd also like to point out that similar activities now being done through letters of permission, at least one instance I'm aware of on Jekyll Island, may also constitute some of the same problems that this permit raises. And that emphasizes another problem with letters of permission, because they're not, unlike this permit, they're not conducted through a procedure requiring a public hearing, or for that matter, as I understand it, public comments aren't even necessarily required to be considered. They're accepted, they're filed, but they're not necessarily considered. And there's no requirement for a person getting a letter of permission to demonstrate that there is no reasonable alternative. So in combination with this, I'd just like to bring to your attention the policy of letters of permission can cause the same kind of problems that this permit raises, and yet it's not through a permanent process. So I'm going to donate the rest of my time to Lisa Norton.
Thank you. Ms. Norton, you have 9 minutes.
Commissioner Williams, may I pass this out? No, I can't, it's 1 minute, so I'll already.
Would you like to pass it, please?
Yes, sir.
Smooth. Yeah.
That's what I call.
Didn't make it through the snake pit here.
You sure you're qualified to pass those?
Apparently not. I think I'm gonna go sit down now. Exactly.
Thank you. Read all of them. Good morning, my name is Lisa Norton. I'm here as a citizen of Glenn County. I became aware that Sea Island Acquisition had revised its application on April the 13th, 2015, 4 days before the SPC meeting scheduled for April the 17th. The timeline of events leading up to this meeting are as follows. On December 31st, 2014 to January 30th, 2014, CRD provided public notice of Sea Island Acquisition's initial application and accepted public comments. On February the 26th, 2015, one day before the SBC meeting where their application was to be considered, SIA withdrew its application. On April 1st, 2015, SIA resubmitted its application with very substantial changes. April 8th, 2015, CRD issued a public announcement indicating that the new CIA application was on the agenda for the April 17th meeting. April 13th, 2015, CRD published staff findings on the new Sea Island acquisition application. In my opinion, CRD has failed to notify the public of the new application and schedule it for consideration at an SPC meeting a mere 16 days after it was submitted. Moreover, the new application was only made available to the public 9 days before the meeting. The SPA explicitly requires a 30-day period for public notice before the SPC takes action on a complete permit application. The reasons for these requirements are obvious. If this kind of game playing is permitted, applicants may start to sneak any manner of additional items into their permit applications by simply submitting a watered-down application, withdrawing it, and then resubmitting a new application. This allows permit applicants to bypass meaningful public comment entirely. The Shoreline Protection Act states in relevant part, and I refer to OCGA 12-5-239, that an application is complete when it contains substantially all of the written information, documents, forms, fees, and materials required by this part. An application must be completed sufficiently in advance of the permit issuing authority, meeting at which the project will be considered to allow for public notice. Now, SIA's current application contains multiple changes to the locations and types of activities requested in its first permit. And it adds a request to install 2 permanent first aid and lifeguard stations. These requests have not been properly noticed and open to public comment. It is ludicrous to suggest that the original application be considered complete without these changes. The permit application clearly requests permission to build structures and conduct land disturbing activities prohibited by the SPA. The SPC should not grant a permit for any of the applied for activities located in the dune field, and the CRD is unquestionably required to provide notice of permit applications for these activities to the public. The CRD's failure to properly notify the public is particularly concerning when considered in light of the SPC's policy of not receiving comment submitted outside of the designated comment period and fewer than 6 working days before the SPC meeting. The SPC should deny this permit outright for reasons specified in the comments submitted during the comment period for the first permit. This application should be denied outright on its merits, and failing that, the SPC should deny the application on procedural grounds and send it back to the CRD staff for proper public notice and a 30-day comment period. Granting the permit at this stage would constitute a violation of both substantive and procedural requirements of the SPA. We are videoing this event this morning to memorialize the activities of the Commission. And I am obviously no threat or opponent for a high-dollar King and Spalding attorney, Mr. Jim Gilbert. He is a very smart attorney. I do ask, though, that you take into consideration that Mr. Gilbert may hope that you have forgotten that although the state is entitled to sovereign immunity, that you as individuals are our public servants, and that we would ask that you not forget that possible federal funding could be effective for the Department of Natural Resources, and that we do provide a public service that shows accountability and honoring the laws of the Shore Protection Act. We don't need a Coney Island on Sea Island. We know where Coney Island is. I'm asking you to please deny this request today on its face, and that it is not procedurally correct. And I thank you for your time.
Thank you, Ms. Norton. Questions from the committee? Since there were some procedural questions, it's my understanding that the application was not withdrawn.
That is correct.
That's one clarification. If you want to address any of the other, I think it might help the committee.
Specifically, the question about the requirement or the interpretation that this project, as being presented today, should have gone back on public notice. It is determined by the staff that this project is just a smaller version of what had already been out on public notice. If you see the board here, it has a list of what was originally part of the initial application that was not withdrawn. They were just asked to not go to the committee at the February meeting. And since, just like we heard today from an earlier project, the SRD project, very similar, they took some components out of the original application and now coming to you today with a smaller version of what had originally been submitted.
Hang on one second, Tricia. Mr. Busey, you're the agent, so you have a chance to respond. Would you like Mr. Barnhire to respond to the comments?
Yes, sir. I'll
Thank you.
refer that to her.
Thank you, Mr. Commissioner. I would like to address first the procedural point. As Carl says, the application was not withdrawn, it was simply modified, and certain aspects that were requested were withdrawn from the application. The point that Ms. Norton makes is that she says that the applicant added first aid stations and lifeguard stations. Actually, those were in the original application. They were simply called 2 gazebos, and in dealing with some of the questions and the comments, we realized that had caused confusion. And so we described those 2 small, they're not structures because they don't have a foundation, but we described them by their function rather than by what they look like architecturally. Functionally, they are first aid stations, they are where the lifeguards are stationed, and so we renamed them in the revised application, but they were included in the original permit. So this is in no way any additional request. It is simply a more limited request for a permit from the committee. The second major point I want to talk about is the chairs. And the chairs were included in the initial application, and they are not included in this application. The reason is we look back at the language in the Act, and the Act requires a permit for a structure or a shoreline engineering activity or a land alteration within the dynamic dune field. And beach chairs are not a structure. They're not a shoreline engineering activity. They're not a land alteration. So they really are not something that has to be permitted under the Act. But we heard and we took to heart the comments that were made by DNR, both the CRD and the Turtle Program, Mark Dodd, as well as comments by Fish and Wildlife, the concern that the leaving of chairs on the beach in front of the dunes at night could in some way interfere with nesting sea turtles. We looked at the data, and we don't think they historically had interfered with any nesting sea turtle. The data on Sea Island are pretty good, and there are false crawls on all the islands, and there are some false crawls on Sea Island. But that's really beside the point. The point is, the question was raised really for the first time, and I think it was raised for the first time because in my reading on this, I think all barrier island beaches on the East Coast and on the West Coast of Florida as well are becoming more sensitive to the possible threats posed by beach use, possible interference with nesting sea turtles. We see that in the literature and in the recommendations that are up and down the East Coast. This had really never been brought to Sea Island's attention before, but it has been brought to their attention now.
and they are going to take steps to make sure that there is no risk of interfering with nesting sea turtles during the nesting season. They will manage those chairs so that that risk is alleviated. So the concern that's been expressed and the concern that was expressed by Alice here today is being addressed by the company, and we will be working closely with DNR as we refine the protocols for the management of the chairs that will start around May 1st, which is the start of the nesting season. So those are the two comments that I heard from the commenters today. I'm happy to answer any questions that any of the committee have. And Dan Busey is here as well if there's anything that's within his area of expertise.
Thank you, Tricia. Any questions from the committee? Staff or the applicant? None? No questions? Chair will entertain a motion.
Mr. Chairman, I move to deny the application as not being in the public interest and wish to speak to this issue at the proper time.
Okay, you're recognized for that proper
You
time.
need a second? Or?
Do I have a second?
I'll second.
We have a second. At this time, go ahead and
My position on this application was not taken lightly. I have read and reread all the documents, visited the property, and had extensive discussions with the DNR staff. This is an important decision. It involves a premier resort destination in Georgia and will set the precedent for the other beachfront locations in the state. It is a complex decision and many issues are involved. In my opinion, this application is badly flawed. Its chief aim seems to be to justify the status quo. The status quo is not good enough. It is inconceivable to me that the designers of such a beautiful beach temple should not have thought of a place for beach toys and beach food, but this seems to be the case. In my opinion, the agents for the applicant and the DNR staff have pussyfooted around addressing the important core issues in an attempt to avoid them or because there are no easy answers. It is also my opinion that the letters of permission process has been badly abused in this instance. What was intended for a special limited use has become a routine way of doing business. This is short-sighted and wrong. I considered suggesting a deferral application, but was concerned that the result would be another patched-together approach that would again not address the root issues. Therefore, it is my suggestion that the agents for the applicant and the DNR staff go back to the drawing boards and work together on a long-range solution, one that will be based on common sense and the spirit and intent of the Shore Protection Act, and not just a careful parsing of the language. That's my motion.
Okay. We have a motion. We have a second. Is there any further discussion? Okay. The motion is to deny. All in favor say aye.
Aye.
All opposed say no.
No.
Okay, the motion to deny carries.
Well, it's refreshing to know that the Shore Protection Committee will actually make a decision that supports the law.
Yeah, they did it twice. They supported the staff, and they supported staff. That's what they very felt like that. Do you ever see it through
No.
Something got into this.
Today is a red letter day.
Yeah.
Something has got into